Hello. Hello there. So, of course, I'm doing this after the Usapang Batas show. Okay, so, well, something piqued my interest while I was preparing for the show before the show started. Okay, so, well, actually, this started. Actually, it just escalate. I don't want to use the term escalate. So, well, this started actually 2 days ago. So, well, um, Dean Jeremy Gatdula, of course, he's my dean at UANP, of course. So he released this, he said this opinion with regards to, of course, the impeachment court. So actually, it started as a in passing statement in one of his opinions on the Fort Pitt issue. So there was this last paragraph, but well, he kind of developed it into a separate one. So well, so Dean Gemay said that, of course, he said that, well, the impeachment trial for the vice president should be presided by the Chief Justice of the Supreme Court. So Article Article 7, Section 3 of the Constitution requires that proceedings against the Vice President be in the same manner as the President. Okay, so furthermore, it removes the Senate President from an ethical dilemma in that he no longer has to preside over a proceeding of a public official. Officially may succeed, or even if temporarily in the interregnum logical to be read with Article 7, Section 9, if the Vice President is indeed removed. Okay, now, of course, some kind of, they supported this legal opinion of Dean Gemay. Okay, so then while I was preparing for the show today, a few hours ago, there was this opinion that was released by another by another luminary in political law. Actually, we know each other naman because Dean Gemay is an author with Central Books. Also, Dean Sarmiento is also an author with Central Book. So, well, a few hours ago, Dean Sarmiento had this say over the same similar issue. Okay, so alright, so of course the screen is not that big. Okay, but this is his post from his Facebook. So of course his question is, should the Chief Justice preside over the impeachment trial of the Vice President? So to answer this question, let us first turn to the provisions of the 1987 Constitution. So he mentioned Article 11, Section 3.6 on the Senate shall have the sole power to try and decide all cases of impeachment. So, of course, he emphasized that, of course, if you read, when the President of the Philippines trial, the Chief Justice of the Supreme Court will preside. So, he said that from the said provision, it is clear that while the Senate has the sole power to try impeachment cases, the Constitution expressly provides that the Chief Justice presides only when the President is on trial. So, there's no similar provision for the Vice President or any other impeachable official. So, of course, well, Dean Sarmiento considered there was silence in the Constitution. So, well, he did some statutory construction. So, first he applied expressio unius ut exclusio alterius. Okay, so if every of course when we speak of that, we speak of it as a tool of statutory interpretation. Okay, then so he related the list as stated in your Article 11 in relation to Article 7 Section 3 about, of course, the removal of office. Then aside from the exclusion unius jury, he also used the generalia specialibus non derogant. Of course, in simpler terms, in statutory construction, general provision yields to a specific provision. I think most of our law students know about that concept. Okay, now, of course, then he went into discovering the intent of the framer. So, of course, he cited certain provisions of the minutes of the Constitutional Convention in order to buttress his contention or his opinion that, well, the president that the Chief Justice should not be the one presiding. Okay, the impeachment trial of the president. Now, of course, that issue. Of course, my first thing that I have to address is this. Number one, who is right among them? The answer there is, well, technically both of them are right because these are both legal opinions. Okay, so of course, we as lawyers, okay, it also includes all the lawyers that you hear in of course in media lately. They have their own opinions on the interpretation of the Constitution. So any opinion, be my opinion as of course an author of constitutional law, opinion of Dean Jeremy, the opinion of Dean Ralph, and even the opinion of even the constitutional commissioners remains to have same equal footing. Of course, this is just how are you going to to explain this, okay, or how are you going to justify it. You have to realize that this is the beauty of law. That we have this, we can always have this discourse, a very very intelligent discourse on things. We might disagree or agree on certain points, but come to think of it, most of the explanation would sound logical, ba? That's the point. It sounds logical. That's why even in the bar exams, you have to note that even if you read the reviewers in the bar exams, there would always have this initial answer, but there would always be a suggested answer, because at the end of the day, you have to determine which one is logical, okay? Which one, even if the soundness of the answer may not be that accurate. If you have a logical grasp of your answer, the same would be acceptable, or if not, it might be a good answer despite being an opposite stance. Okay, so that's the beauty of law. To be blunt about it. Okay, so now of course the question now is, of course, we have to also understand the philosophical drive. I think there should be importance in discussing philosophy. We have to consider that, of course, to be to be def in all due deference. Of course, Dean Gemma is not just a political law expert. He is also an international law expert. He is actually his first forte is in trade law, but of course he's now concentrating on constitutional law and public international law. He has a JSD in Cambridge. Dean Sarmiento is also a legal, is also a heavyweight. It comes to political law. He has this grasp of international law. He does his moot court coaching and participation every year. Of course, he is one of those better professors that we have in the Visayas, especially with USLS. Okay, but of course, I have to make a token. Let's say, of course, I have to little bit side with Dean Jeremy with this. But how I'm going to side on Dean Jeremy with this stance? So we get it. They both have a sound legal explanation. But you have to understand where Dean Jeremy is coming from. So aside from that, one of the things that Dean Jeremy has is he has this knack of looking at it more of on a philosophical point of view. So, well, the issue with decisions these days, okay, or maybe previous decisions made by courts, is there is this lack of drive on how are you going to drive your decision with more philosophy. And it's being disregarded for a lot of for it's been disregarded most of the time. But we have to note that, of course, philosophy is important. Dean Jeremy, when he has to dissect some of these provisions of the Constitution, he always goes to this his philosophical thought. And knowing him, of course, Dean Jeremy is conservative. Of course, is conservative. He's open about saying that he's conservative. At the same time, being conservative, he is more into following more of an originalist interpretation of the Constitution. So, if you would observe in his comments or in his writings, he always emphasizes he always emphasizes on what the framers think at the time that the Constitution was established or was ratified in 1987. He always has this emphasis. Okay, so are we going to make sense of his explanation? Okay, so is it logical? Well, for some people it's logical, but how am I going to buttress it in a more legal sense? Well, let's go back to Article 11 section 3. Okay, so there is this list, diba? So is it section 3? Oh yeah, is it in section 3? I think it's in paragraph 1 or 2. Okay, so when we speak of who are impeachable officers, there are a list of impeachable officers. If you can recall, there is this list of impeachable officers that is in your Article 11. Okay, so I think let's try to let's try to go straight to the horse's mouth. So since we have been browsing this. Okay, so let's go straight to the Constitution itself. Okay, all right. So where am I? Okay, all right. So here's the Constitution. So we have our of course article. So let's look at the list first. Okay, so there is this list of impeachable officers. It's Article 11, Section 2. Okay, so it's listed here that the President, Vice President, members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman may be removed on office on impeachment for and conviction of culpable violation of Constitution, treachery, bribery, graft, etc. Let's concentrate on the list, okay? Because if we're going to go also with statutory construction, if we're going to follow on through Dean Jeremy's argument, okay, you have to relate this because of course we are talking about, of course, if the Chief Justice is relating it to Article 7 because the removal of the President should be equivalent to that of the removal of the Vice President. So Dean Jeremy is on that point that he wants to have that removal. Okay, he wants to have that if it is the same as the President. Okay, the removal should be also there is this equivalence. Okay, there's this he's simply saying that it has parallel equivalence. Okay, now would that make sense? That parallel equivalence, that's the one that's being countered by Dean Ralph in his argument. But how are you going to put logic in Dean Jeremy's argument? You have to go to your Article 11 Section 2. You know why? Okay, so who are impeachable officers? Let's go back there. Okay, so let's go back to, okay, so we have in Section 2. So there is this list. It's the President, Vice President, members of the Supreme Court, members of the Constitutional Commissions, and the Ombudsman. Okay, would it have logical sense to include the Vice President as one in which the Chief Justice should be the one presiding? I think there's validity to what Dean Jeremy is saying because you have to look at the list itself first. So remember that the President and the Vice President, although of course we know the roles of the Vice President. Of course, the President is the power of the executive. The Vice President is, for all intents and purposes, is the quote-unquote spare tire. We can, well, whether we like it or not, that's actually the actual designation unless the Vice President was assigned the cabinet position. Okay, so you have the President and the Vice President. Now you have to note that the President and the Vice President, they are both from the executive department for all legal intents and purposes. So if that is the case, it follows that, of course, if there would be an issue on impeachment of officers arising from the executive department, the Vice President is included there. Now, whether or not the role of the Vice President is active or not, I think it behooves the question because, well, they are both from both executive department. Of course, there is this importance that when if there should be a causal relation to that, in a sense that, of course, if if the officials would come from the executive department, well, it follows that there should be a you call this there should be a similar sense. If you're going to try out the president, it follows also that you have to also try the vice president with equivalence with the president of the Philippines. Okay, so if that is the case, it would be appropriate that, of course, the chief justice, it not appropriate, um, it can be legally, it is legally feasible and it's legally arguable that, of course, the chief justice should preside, because we're talking about officers from the executive department. Now you have to contrast this with the others in the list. So obviously, for members of the Supreme Court, you cannot have the chief justice presiding it for all illegal intents and purposes, because of course the members of the Supreme Court are from the judiciary. Okay, and of course it would be absurd that, of course, the chief justice will preside over the impeachment of of course it's obvious but it's not listed. But I just want to derogate, or I just want to emphasize on, of course, the distinctions why we go to the why we close into the office. In my view here, you can look at it on the status of the office, because the members of the Supreme Court in the judiciary, the members of the constitutional commissions, although they are not part of the traditional separation of powers officers, of course, they are independent offices, and of course, it follows that, of course, the Senate should only try them. Then, of course, the Ombudsman is also a special office with respect to investigating graft and corrupt practices cases, and it's specified that they are subject to impeachment. So you have to to justify Dean Jeremy's stance here. Well, it follows that, of course, the requirement of a chief justice should be made not only with the president but also with the vice president, because we are talking about officers of the executive branch of the government. And I think that would be a more plausible buttress, or a plausible defense on the stance of who should preside or not. Okay, now, whether or not this is going to be legal, whether or not this is going to be a legal issue later on, of course, it's subject also to someone challenging it, or what would be the correct procedure on the said matter. Okay. Now, anyways, so I hope that, well, I hope that I hope that I was able to, share my thoughts on this. Of course, shout out to Dean Gemma, and of course kay Dean Ralph. Actually, it's good that there is this, exchange of opinions, or exchange of legal views, because of course this is where, constitutional law would develop. After all, the constitution, aside from the interpretation, the legal framers, all that was discussed in Francisco, of course, the easiest interpretation or legal views would tend to evolve over time. That, of course, it's also beneficial with respect to the law student, especially us in the study of constitutional law. Now, of course, additional, if you want to learn more on how Dean Jeremy's news or mind operates, would like you to I would like you to I would like you to look at, I would like you to, if you want, you may want to read his book on natural laws and the limits of judicial power, available in Central Books. Okay, actually it's a good read. It's if you read it, you would be open to other thoughts with respect to the study of the Constitution. Okay, so as I said, always with my students, always have an open mind. You don't have to you are always allowed. Of course, there would always be this, fixed guidance in the study of the law, but feel free to, express your ideas, as long as these are logical, these are legally sound. There is no problem with challenging, okay, or challenging what is the legal order or what is now, because as future lawyers, it is right that we have to, as futurists, you have the right to evolve the laws, evolve the constitution. So see you around. Tata.